Welcome back to Talking Points, and thank you for staying with us. It is Friday, and with Friday comes good things, such as Janelle John-Bates in studio with us. Hello.
Hi guys, morning.
Morning.
Good to see you.
Good morning, viewers. Good to see you all as well.
So,
everybody's looking sharp, like you're all ready for the weekend.
I'm
Sharp? I don't know if I would say I look sharp.
I'm ready for the weekend.
Ketan looks like he's ready for a night at the Roxbury.
Exactly. I'm ready for a night of just fun, and we'll pause on that.
Well, in his case,
just leave it right there. Yeah?
in his case, his nights are filled with bed, and it's mainly for sleeping. Am I right?
Well, again, we'll just leave it right there.
Okay.
So, let's not get into too many talking points in that area. But anyway, it's good to see you, Janelle. The ruling by the Privy Council in regard to the local government extension, fortunately, didn't go the way of the government, 3-2 in terms of the law lords. I said, unfortunately,
Okay.
for the government, it didn't go in their favor.
It didn't.
3-2 in terms of law lords. What is your take on this? We've heard the Attorney General's take. I'll ask you your thoughts on that in a moment. But on this particular ruling.
My take on it is, I read it, all 27 pages of it, and when I was reading the majority view, I was like, yeah, that makes sense. I totally agree with you all. The people have a right to vote, and this extension of the year almost takes away that right from them. Essentially, it puts it in the hand of the government to decide when they could vote on that issue. But then I read the minority, the dissenting opinion, and I was like, well, I agree with that too. Because essentially, the thing that troubled me that came out in the dissenting opinion was, well, if you're saying that the sections 11.4 and so forth does not apply to the incumbent councillors and aldermen, then what applies to them? Because the old act, the section has been repealed, this new act is in here, so there's a lacuna. So what then is the term of incumbent aldermen and councilmen? What applies to them? And I thought, well, that is actually a very good point. So my takeaway from this whole thing is clarity. Clarity in drafting. Clarity in drafting is so important. Sometimes, drafting is not a very sexy topic, I would think, in law school. I don't know many people who come on like, yes, I want to be a drafter. But this case shows us where clarity is so important, because essentially they're saying there is no transitional section that speaks to what applies to current councilmen and aldermen, which in a sense forced the majority of the Privy Council to, using the words of the dissenting opinion, imply a sort of special transitional period into the section. You had to then interpret the section in a particular way. So that's where clarity in drafting is important.
It's interesting because, technically speaking, there is a very good argument legally, it seems, that the minority opinion is right. My thing, though, is that it's hard for me to personally argue for it, because when this whole thing initially unfurled, we identified on Talking Point that very same thing that you identified initially, that the majority opinion identified. The incumbents were elected for 3 years, how could they serve for 4? Like, is that ethical? Because I think it reached the point now where it probably is legal. It probably is, but is it ethical? So now the question is, to what extent are the law lords looking at it and it's like, is it really on a basis of legality or on reasonable ethical grounds?
Their interpretation has nothing to do with ethical grounds. It was simply a matter of, for them, statutory interpretation. Because an interesting point, well, it was interesting to me that they brought out is that when the appellant, Mr. Balgobin, made his argument before our Court of Appeal, his primary argument was the constitutional point, that this extension of time is sort of breaching the constitutional right to vote. And they completely shut that down. The Court of Appeal said no, and the Privy Council agreed with them. It has nothing to do with any breaching of rights. The government does have a right, the Parliament does have a right to extend terms if they wanted. They are saying the point here is statutory interpretation. The Privy Council is saying, well, the majority is saying, they found a natural reading of it would imply that it does not apply to aldermen and councilmen incumbents. But they are saying, actually, but we are not actually saying that the way the Court of Appeal saw it is not plainly wrong. Because sometimes they could say, tell you that, they could say, the way you see this, plainly wrong. They are saying, well, I could see why the Court of Appeal would see it that way. But they're saying, but we don't see it that way, because they found that going beyond the express language, looking at the purpose and the context, that it would make more sense to the majority that it did not apply to the incumbents. The dissenting judgment is like, well, actually, no. To me, it's very clear. To me, it's very clear. The express language is it applies to incumbents, because if it didn't, then what applies to them?
This entire thing for just anybody watching, right? So, it's absolutely confusing. 27 pages of the judgment. It's absolutely confusing, especially if I'm reading the three law lords and their decision versus the two dissenting opinions. So I could understand if because even me sometimes it's very hard to follow these things. And not being a legal mind who's totally versed with the legal jargon, I could simply understand where the confusion can be. But that is the thing. You've got 5 lords with this power. And at the end of the day, just like any other lawyer, it comes to legal opinion when a judgment is being laid. And the issue is it could have gone in the government's favor or against the government's favor because it's 5. It's 3-2. I think that's one of the arguments that the Attorney General was trying to make because he referenced the appeals court in TNT as well in their decision. And he made that point that you just said. At no point during the judgment did they say that in terms of Ravi Balgobin Maharaj's argument in our appeal court, they just shot that down immediately. At no point in time did they say it went against the constitutional right to vote. But at the same time, they're also saying they have an issue with government and by extension Parliament deciding the life of elected representatives.
Well, no, we have to be more specific. They didn't say they have a problem with the Parliament having that.
Well, they said they
right.
couldn't agree.
They said, and I kind of paraphrased it here, so I'm going to read what I paraphrased. It cannot be assumed that the Parliament intended to compromise the electorate's right to choose their representatives without that being clearly outlined in the Act. So what their problem, again, is clarity. They are saying it is nowhere in there clearly states that the government had the right to extend the life of the incumbents. They are saying, if you wanted to do that, you could have expressly said that, and you didn't. So it's not that we are saying you can't do that, we are just saying you did not expressly say that, so therefore we don't think you have that power.
So that the next argument that one would make in analyzing this entire situation is, who are the lawyers that advised with regards to the amendments to this particular act? Because if there's not much clarity, at least in the instance of the arguments from the Privy Council, because remember it went through the appeal court in Trinidad first, if there's no clarity, there was ambiguity, then on what grounds were they advising that this is the way to go? We should,
write the
amendment.
Well, when I was thinking about that this morning, I'm like, I don't want to question who are the lawyers. I mean, we have the draft, the section. There is the name of the section escapes me in the AG's office that does the drafting, right? But my thing is, what were they told? We don't know what they were told or what were they asked. I am drafting based on my instructions, and it went to Parliament. It passed. I did not have an opportunity to go back to the Hansard to see what were the arguments. Was this point brought up? Was it ever brought up in parliamentary debate? So, your guys, does it apply to the incumbents or not? If that was never brought up, and I think in the judgment they said that there were no extraneous material to help them understand the purpose and context, which to me implies that there was nothing in the Hansard for them to even make a decision on the intention of Parliament.
Because I would hope that the opposition would have raised this issue then, at the very least, and not after the fact. So that was one aspect of it. You said, well, drafting is important, right? And Ketan was kind of, I don't know if you were looking to imply this, but to me, one of my takeaways, actually, even before you brought up that you think that was the root cause, I thought it was just, look, it was not written well, because it seems as though the debate, when you boil it down between the Privy Council law lords, is what you think is the default reading, given that it's missing a whole section. And I do have to question, is it common practice if I'm told to draft a piece of legislation? I don't know how obvious it is, but the transition between one set of rules to another set of rules, because you can't just stop. Local government just can't just, well, you know what, we'll have a leap year. We'll go on sabbatical. We just won't operate, until we have our next election once our 3 years are done. Like, did nobody at any point in time, and I get it, it's not necessarily the drafter's job, but from the people on top who's giving them the instructions to even them, like, nobody thought, hey, we do have to actually kind of figure out what's going to happen in between.
Well, you see, that's an argument, but you see, we have to go back to the fact that this act, there was power in the act to proclaim peace or the whole of the act whenever the government gave that signal.
Right.
So if you're drafting, maybe in your mind, it would have been proclaimed after, because remember, it was proclaimed, that particular section was proclaimed in November.
Right.
Local government, their term was supposed to end in December. So then it could have been that we actually didn't think you were going to proclaim it until after the new crop of aldermen came into, or just
I think it may...
Before.
And I think,
That's going down another line.
because at this point in time when this legislation was read and we had this debate here on Talking Point, I don't think you were with us as yet actually. No. We were making the argument that, listen, you should have the elections first and then you can stand up in Parliament and lay this before Parliament. And nobody will... I don't think there would have been that much disagreement towards it if it had transpired after the local government
As in
elections.
You declare the elections.
Precisely.
Then you
look to extend the life of
and
councillors.
then people know they're voting in people for 4 years.
4 years.
But then somebody might make the argument, hold on, I voted in this person for 3 years. Mm-hmm. I didn't vote them in for 4 years. So it could have gone either way, but it may have been better or more in the government's favor had they done it after the local government elections.
Well, but you know, the dissenting, oh gosh, you made a point there that I wanted to address. The dissenting judgment said, look, when you voted in the person, or when the person came into power, when they were elected under the act that just simply says you're here for a period as per whatever, the provision of the act. Mm-hmm. So the dissenting judge said your time could be lengthened or shortened. No, it's not about you can't just sit down there and say, well, I'm here for 3 years, because prior councilmen and aldermen have had their time extended before. They actually mentioned that. So this is not new in our country. They literally said that.
Let me ask you a question now. Mm-hmm. Now that this judgment has been laid, we're waiting on the Prime Minister and by extension in conversation with Cabinet to decide when local government elections are going to be. It doesn't explicitly state it needs to be called then. But as pointed out this morning in an earlier conversation I had, because of this judgment, it now says that we are overdue for the election.
Essentially.
So is it now that because we are overdue that councillors across Trinidad should vacate their office, should actually resign?
That's a good question, and I will err on the side. I will say, like the AG, I have to be advised by those who are more senior to me.